everyone. Thank you for the opportunity to join this important discussion. My name is Desi Yunitasari, and I'm presenting this paper together with my colleague, Devi Yusvitasari. We are from Melbourne Law School. First of all, we would to apologize for being off cam during this presentation, as we are currently experiencing heavy rain and unstable internet connectivity that may affect our signal. I will truly appreciate your understanding. And today, we are honored to present our social legal research titled Integrating Women's Rights, Women's Digital Rights into Legal Education, a case of online gender-based violence in Indonesia. In the past few years, Indonesia has witnessed disturbing rise in online gender-based violence, from cyber harassment and doxing to deepfakes and non-consensual image sharing. While these harms occur in digital spaces, their impact on women's lives is deeply personal and often devastating. Despite the growing urgency of this issue, we find that legal system frequently fails to protect survivors, and in some cases even criminalize them. So this reflects not only legal contradiction but also a gap in legal education, which rarely equips future lawyers to address these digital harms from a gender sensitive or human rights perspective. We know that there is a surge in online gender-based violence, especially the forms include harassment, non-consensual image or video sharing, doxing, deepfake manipulation. And the data from National Commission on Violence Against Women notes there is a 300% surge in online gender-based violence related reports over the last 5 years. And the cases were officially investigated only about 18%, and 6% led to convictions. This case that illustrates the crisis in a deeply reversible case, AI-generated content was used to extort a woman. Instead of receiving protection, the survivor was prosecuted, was often prosecuted under the Article 27 of OED, or we call it Law on Information and Transactional Information, spreading abundant content that illustrates a legal paradox such as survivor risk recriminalization while perpetrators often walk free. And legal framework reviewed the law on sexual violence, or we call it UTPKS, especially under Article of 14, explicitly criminalized digital sexual violence, including non-consensual sharing of sexual content that treats our courts using intimate material, especially including deepfake pornography that recognize digital spaces as a site of sexual violence. And also the OOEDA, especially under the law under the Article 35 that prohibit identity manipulation in digital platforms. This rarely used against perpetrators deepfake or identity-based attack, because there is an ambiguity in terms like unsuitable content that enables selective law enforcement. And the next law, also the law number 44 of 20, 2008 on pornography, under the Article 4 junto under Article 29, that criminals creation, possession, and distribution of pornographic material that intended to regulate explicit content regardless of consent, creating risks for survivors, because victims whose image are shared with the consent may still be charged as distributors. So there is of a clear distinction between consensual production versus non-consensual misuse. There's also a law on personal data protection under the Articles 66 that prohibit unauthorized use of personal data that applies to doxing and identity misuse. There is these structural gaps, whether from legal, institutional, technical, and cultural, can create an ecosystem where perpetrators thrive and survivors are really traumatized. Especially, there is a legal contradiction, such as victims of gender-based violence are often prosecuted under laws meant to combat cybercrime. For example, women whose non-consensual image and leak may be charged under the Article 27, as I said before, and also there is an institutional fragmentation such as multiple body oversee cybercrime and digital violence, especially in National Commission on Violence Against Women. But these institutions often have overlapping mandates, or they don't have the capacity to put into practice the law, especially to legalize the law. I mean, and they use different victim definition and standard. And also the next one is limited digital forensic capacity, because few law enforcement units are equipped with trained digital forensic investigators, gender sensitive protocols for evidence handling that can lead to poor evidence collection, impunity for perpetrators. And then the last one is absolute injustice in legal process, because survivors face skepticism, victim blaming, or moral judgment in legal proceedings. The bandwidth legal theory is the challenge and dramatic legal model. They can expose gender bias in the way law defines rights, justice, and harm. Law often fails to recognize the structural nature of gender-based violence, and legal objectivity can mask deep inequalities and exclude women realities, especially regarding the gender-based violence in this era. In the context of LGBT, especially, women's legal theory demands that digital harms like deepfakes, image-based abuse, online harassment, so on, can be treated as legitimate gender violence and not private or trivial dispute. Why these theories matter? Because they reveal how law is not neutral. It embeds cultural and gender assumption, because law is actually can be applied based on the culture, how the culture can be normalized, especially regarding the gender bias in this era. Reform must go beyond status, because it must reshape how legal actors think, reason, and value the knowledge. And using these lenses, our research advocates for inclusive legal reasoning and justice that listen and believes survivors. However, there is an epistemic injustice, as I said before, because it refers to a form of injustice done to someone in the capacity as a speaker or knower, and their testimony is undervalued, not because of its content, but because of who they are. And in legal forum, this occur when a lot of people, especially the legal makers or some sort of things, um, when women experiences of digital violence are dismissed as overreaction, or the they can be ignored because of there is a lack of credibility and so sort of thing, and survivors are not believed of their own, or their credibility is questioned by the lawyers or any people around them, and harm is minimized due to moral bias or societal stereotypes, because we know that sometimes in our culture we call the like gender-based violence is recognized as a taboo thing. So especially in LGBT cases, there is sometimes there is legal professional that asks, why did she send the image? Was it really that serious? And any other question that can undermine survivor's credibility. And Indonesian legal education, actually, there is an educational blind spot. That because current curricula in most Indonesian law faculties seldom address gender-based violence, especially in online field, as a distinct legal issue, and do not include feminist legal reasoning as part of the core legal theory, and also lack of exposure to digital rights frameworks, survivor-centered advocacy approach. And what is the consequences? The consequences is that the future legal professionals are unprepared to handle the complex and rapidly evolving realities of digital gender-based violence, because resulting this can be perpetuated by the knowledge gap, such as student graduate without understanding how technology intersects with gender harm, or their ability to analyze AI-generated abuse, their awareness how legal processes can create traumatized survivors, and how their skill can engage with interdisciplinary tools like digital forensic or trauma-informed interviewing. This can perpetuate low conviction rates. Victim blaming includes continued marginalization of women's civil rights. And there is a need of legal curriculum innovation because we know that the legal education is the first place to educate people, and then that can change the culture, that can change the reality of that women now is usually experiencing the gender-based violence and do not get justice. The first one is integrate into core law courses such as feminist legal reasoning, AE and law, and LGBT case law and comparative model. And the second one is build interdisciplinary skills such as digital forensics for legal professionals. And the second one, survivor-centered legal advocacy. And the third one, practice-based reform such as clinical legal education on strategic litigation and partnership with NGOs and women's rights network. This can be explained by the next slide, such as the feminist legal reasoning, how to teach students to critically analyze how legal norms and practice impact different genders and identities, particularly in case of digital violence. And and now how introduce foundational knowledge on artificial intelligence, and especially about their impact on the rights of women when they are trying to explore the technology, such as regarding deepfakes, data abuse, and online harm. And the last one, the third one, regarding the LGBT case law and comparative models, to examine landmark cases from Indonesia and globally, and to understand how courts respond to digital gender-based violence and evolving gender-based abuse. And the second one, regarding the interdisciplinary skills, digital forensic for legal professional means how to equip students with ability to interpret basic forensic evidence such as image verification and work with technical experts in education involving digital harm. And to represent, try to what is it like to advocate the victim when they don't know how to not being a gender biased lawyers and some sort of things, they will fail to advocate or to give the justice for the victim. So how to train future lawyers to apply trauma-informed approaches, such as prioritize victim safety and dignity, and make sure that they don't get re-victimization during the legal process, or during the advocacy, and reduce secondary victimization during legal proceedings. And the last one, practice-based reform, such as legal education on strategic litigation that offers hands-on experiences where students work on real and simulated LGBT cases, visit NGOs, and explore impact and litigation strategies. And the second one, partnership with NGOs and women's rights network, because when the advocates or lawyers have a collaboration with another network, they will expand their impact on advocacy, create such as to create no formal collaboration for extensive casework and research projects, bridging classroom learning with frontline legal and advocacy work. Why legal education reform matters? Because it can empower students to understand intersectional harm, pursue gender-sensitive justice, and shape future law reform and public policy. So the study calls for the first one, structural legal reform, and second one, inclusive and critical legal pedagogy, and the last one, a justice system that relieves survivors. Thank you very much. I think it is all from our presentation.